Welcome back to Art of Law. You might see from both cameras that it looks like we're in the same room because in fact, we are in fact in the same room, and we do the pan just to prove that we are in fact in the same room. So we thought we'd talk to you today because we've been discussing about videos that I put out on Black Belt Secrets about newspapers and magazines printing stuff. So we're going to do this as a conversation. So, excuse me, but we're going to look at each other now because we're in the same room. So on lots of my videos, lots of people have said these magazines, these newspapers could just make this stuff up. And to some extent, that's true, isn't it?
To a certain extent, yes. I mean, obviously, the press will always try to put, claim to put genuine stories in there. But it's what are the source of those stories? And you'll see things like a source close to. I mean, these are all little giveaways. And you get this a lot with political reporting. So if it says, a source close to the cabinet, that usually means the cabinet. A source close to the Prime Minister is the Prime Minister.
The Prime Minister.
But when it comes to sort of celebrity tittle-tattle, this is a big problem with the Varney Rooney thing as to where the information came from, and with all the phone hacking. Because, when I used to work at the newspapers, a lot of these stories, they come from either the celebrity themselves, their PA people or their agent, or their friends and family, sometimes with or without permission. I mean, the whole thing with Varney Rooney was you were leaking that without me giving you consent to do that. But a lot of the time it is, can you have a word with somebody at the gossip column? When you see these people washing their car in sort of like tank tops and shorts and things, and it's, oh no, the paparazzi are here, how terrible, just as I'm washing my car in full hair and makeup. Yeah. There is a lot of that. But if it's a sort of more serious story, I mean, obviously you've got sort of, defamation potential claims, but it's very hard to bring a defamation claim against a newspaper or journal that has done the pre-publication advice stuff. I mean, that was my job, was going, here's what you can get away with. And all
the checks. So let's break this down. Let's go back to the beginning. So in essence, the comment for discussion is they could just print whatever they want because they just say a source told us this. So we'll come full circle, we'll come back to that. So the point is they get a source, let's say they get a source and they're not making it up. They print this stuff, they say they've got it from a source. Now the difficulty is no one can take them to court to say, tell us who told you this so that we can whatever, because all sources are protected, which we've discussed in many other videos. For those that don't know, there is a protection for newspapers to protect their sources, wherever the information comes from. So you can't take them to court to get that out of them. So in that sense, they do just print what they want.
Yes.
However, hurry up.
There's a lot of people under this table.
Yeah, we can cut this bit out of here.
I like it because the dog's asleep at my foot again.
Yeah. So you can't get them to court to say, tell us who told you this. So that's a non-starter. So what you've got is this story going into the paper. As you just said, what they do is say they've been approached for comment, or this is their comment, or they've denied it, or they've refused to provide any comment. And what you get sometimes is there's one I was looking at the other day. Was to do with Upworks, I think it was called. There's a franchise owner of McDonald's, and one or other didn't provide a comment. I think it was McDonald's refused to comment, and the franchise owner provided a comment. This was to do with that other story of them being sued for $800,000 for hot chicken nuggets. And some people will say, that's ridiculous, it's hot food. Well, actually, I've seen the photographs. I didn't show the photographs because they're quite horrendous. And you think they must have been 300 degrees or something ridiculous. So
well, yeah, this is it.
So the point was they printed all of this information, and even though it was a court case, but because they'd added comment and a spin, I suppose, they said they'd approached them for comment. One or other, I can't remember which way around it was now, but one or other had commented, the other hadn't. And so that's the point. But then, so we're talking about, we've got Harry and his phone hacking case.
Yes.
We've got the Varney Rooney stuff and the tit-for-tat argument and Instagram and everything else. And now we've got the recent stories, because there's a few of these, and I've been percolating them for a few days as to what to say about them. So I'm going to split some of this video to go out on secrets, and some will go out on Art of Law. Well, the whole thing is going to go out on Art of Law, but we'll split some off for secrets. So there's a few things. One rumour, I suppose, that's been printed was that they were denied the return flight on Air Force One or something, and that's what the paper printed and said. Yeah. So if someone were to say that's nonsense, there's not much anyone can say about it, is there? Because
well, no, I mean,
can't press them for.
Yeah, assuming it's like you get over all the defamation hurdles in the first place. It's defamatory. You have suffered a loss. There's a relevant jurisdiction to sue in. Who do you chase? Because, like I say, if the newspaper's saying, "Well, we have been told," now there is this idea in journalism that you should always get two sources for any story, but there's no obligation. And in the other video where we explain about how the press controls and regulates itself, there's lots of guidance there, but there's not really any way of enforcing it. But let's say you say, oh, that is defamatory, and you want, there's nothing you can do with the newspaper. They've got a public interest defence, or they've given you the potential of a right to reply. They don't actually have to give you they only have to offer you the right to reply. If you say, well, no, I'm not commenting, it's not true, I'm not even going to respond to that, they can just say, we approached the subject for comment, and as at the time of publication, we've not had a response.
And what if they didn't do that?
Well, generally speaking, we used to have this thing called the Reynolds defence, which was a sort of set of factors that would give you protection if you were newspaper sued for defamation. That was specifically abolished in the Defamation Act. The courts have said, we're not trying to, we're not going to sneak Reynolds defence in through the back door, but a lot of the time they do and go. However, it is a handy reference and it's a checklist. But the idea was it was to give more freedom to the press. So the restrictions have been lessened. Generally speaking, though, it's considered to be very good practice to cover yourself to at least give the other party an opportunity to respond. However, if it's a time-critical story, you don't have to. Also, if you just know it's somebody who's never going to respond, then why bother? So if I go do a video and I say something about a celebrity, do I email them and say, I'm commenting about you on my YouTube channel, do you have anything to say? They're not going to get back to me.
No, exactly. Likewise me. I mean, none of them are going to respond to me.
You're quite famous.
No, but look, you're right. No one's going to reply, so why bother? So let's say that they do print this story, because this is what people have said in the comments. People, they could just make this stuff up. Well, yes, is I suppose the answer, isn't it? They could, in theory, just write anything.
There have been scandals. I mean, not so much about reporting on individuals. Remember all the stuff, a lot of stuff in the Gulf War or Gulf War II, where there was the journalist who just literally just making everything up, just watching CNN. I mean, I love the fact that it's even referencing The Simpsons, where they have the little school newspaper, and Milhouse, when it all falls apart, he goes, I lied about that time, all my time in Basra. So, this is acknowledged and recognised. And some newspapers do just churn things out. I mean, I'm not sort of dismissing any of, particular newspaper, but because newspapers have so much protection, because like I say you go, right, well, I can't go after the newspaper, I want the source. Well, newspapers, they don't have to reveal their sources. That's unless it's like a national security.
And in which case it won't be public anyway. It'll be very, very private affair. And
I mean, the government might sort of go, they might go after people. They've gone after whistleblowers, but even then the courts give them a lot of protection. Also, we've got this other video coming out about Norwich pharmacal orders. That's the thing where you say, right, okay, I accept you've not done anything wrong, but you have some information that would allow me to go after the right person. You know who I need to go after. You can't do that with a newspaper. You can do that with generally, but like I say, there's this idea of freedom of the press and that sources have always been protected. So theoretically, there's nothing to stop a newspaper making things up. I mean, there's enough real news out there arguing they don't have to, but they certainly put, obviously they put a spin on things, they overhype things, they extrapolate, the kernel of truth into a more interesting story. I mean, as we always used to say, as people say in the news, if it bleeds, it leads. In other words, it's got to be sort of interesting. There's the old idea that, dog bites man doesn't get reported, man bites dog does. And there is a bit of especially, because now it's not like the old days where, just had to get one newspaper out a day and that was it. You've got your websites, you're constantly updating, you've got to compete, you've got to be tweeting headlines all the time. So yeah.
It's got to be new, got to be fresh. It's like I say, for anyone, I mean, we're so grateful to everybody subscribing here on Art of Law. Hint, click the button below. We're so grateful for it, but it's all about consistency. I mean, I've never had, slight tangent, which hopefully you'll find useful, but I've never had a problem with competition. I've never had a problem with other people getting involved and doing things, and I've always been willing to help other people do stuff, business, whatever it might be, because unless you're, Google and Apple and Amazon, and you're fighting for that, percentage of the pie, which is divided into 3 or whatever, then you're never going to be big enough to worry about the competition. So I always say, this is how you do it, this is how you go. So if anyone is ever interested in creating a YouTube channel, the number one thing is it's got to be interesting, which means it's got to follow what the audience wants, which is, it's on point, because this is what the newspapers are talking about. Whether people agree with it or not, enough people want to know what's the next move for Harry and Meghan, what's going on, and what they're being dished for. And also it's got to be consistent and persistent. So it's got to be continuous new content all the time.
Absolutely.
And so that's what the newspapers are doing. And I come back to it every time, and I do it to, I'll be honest, I do it to wind certain people up because they don't like me doing it. So I'll do it every time. But Charlie Veitch is one of these sort of citizen journalists. He's mellowed in his ways somewhat more recently. Not always, you understand, but sometimes he does. And I find it entertaining just because he does certain things to wind people up, believe it or not. And so when I say, there was one particular comment about him, which I find hilarious, in that someone said, I don't like that Charlie Veitch because he walks around talking about things and filming them as they happen. I'm thinking, what do you think newspapers do? This is what a newspaper does. And so the point there is it has to be consistent, it's got to be new, hence news, and it's got to be interesting. So that's the point. So, however, leads me on to a question. Where does this come close, if it even does? Because if it wasn't obvious, I've never worked in the newspapers. Al has. I hope that was obvious by now. Where does it come close, if at all, to malicious falsehood? Now, malicious falsehood, for anyone watching, is you're saying something that you know is wrong deliberately to cause some trouble. Yeah. That's the brief essence of what a malicious falsehood is. You're spreading deliberately fictitious rumors to.
Yeah.
It's not quite defamation, but
the thing with malicious falsehood is that the statement doesn't have to be defamatory in the sense that it makes people think less of you. I mean, like I said, the example I've given is, somebody asked me, I've got Dan's phone number, I want to instruct him on a case. Oh, sorry, no, Dan's away doing his charity work. He's not available, but I am. Well, no one's going to think any less of Dan for doing charity work, but I have cost you money. By implying that you're not available for work. Even more so that I have actually then tried to step in myself. Although that's not necessary, it's enough to cause somebody else a loss or harm. It doesn't have to necessarily be financial loss. The test actually, the phrase they use is calculated to. But again, this is one of these old phrases that's possibly evolved a little bit. You don't have to sit there being all sort of, calculating in the wahaha planning sense. It's actually, it is a bit of an objective test, because would an objective, a reasonable ordinary person say, you saying that is bound to cause somebody a loss? I mean, the classic example is, it's malicious falsehood to incorrectly say somebody is insolvent. Now, nobody thinks the less of anybody for having financial troubles, but this crops up a lot with businesses, because businesses can bring claims for malicious falsehood as well. They have to show the financial loss aspect. But yeah, suggesting a business is in financial difficulties, that's not defamatory, because so what? Everybody struggles, it's a recession, but it causes them a loss.
And so the reason for the question is, some of the newspapers, I'm not going to name any of them, people can find it for themselves, have talked about rumours of them, Prince Harry and Meghan, that is, separating, him being living by himself, either on the weekends or spending time apart or this sort of stuff. Her having spoken to divorce attorneys, I think I read somewhere, and that it's all up in the air and they might be getting divorced. And to be honest, I take it all with a pinch of salt, because it's like, well, again, it comes full circle. How do you know it's true? Well, you don't. Can you prove it's true? No, not unless they say so, unless they comment and respond. Can these articles, authors just make it up? Yes, in theory they can. But then how far does, if it's not defamation, which it isn't, they might be getting divorced, so what? It's not defamatory. But how far does that come towards a malicious falsehood? And what potentials? Because a lot of what they're doing is based on them as a couple, isn't it?
Yeah.
So it could have a financial implication.
Well, yeah, because they have a brand, and as a couple, they are supposed an unincorporated association. But I've discussed on other things that partnerships in the legal as well as sort of marriage sense, they can have an existence on their own. They can sue, although normally partnerships would sue, as individuals. So if they wanted to bring a claim, they would bring it as, Meghan and Harry as their separate people.
Yeah.
You've also get into some breach of confidence, of course, because that's the other thing. You've got your reasonable expectation of privacy, the state of your marriage being on the rocks. That could well be held to be confidential. And one thing people quite often don't understand is, just because you're a public figure, even if you voluntarily put a lot of your private life out there, it doesn't make it a free-for-all.
No, not for everything. Exactly.
No, the courts have said effectively that you can pick and choose which areas of your life you put into the public domain. Now, if you go out there and say we're a happy couple, everything's hunky and dory. Now, one exception, one defence to breach of confidence is to correct a false impression. So if somebody is claiming one thing, but the truth is something different, and this is even if there are like NDAs in place, you're allowed to say, well, actually, that's not true, because the saying goes, there is no confidence in iniquity.
Exactly, and to put that another way, just because there's an agreement to keep things confidential doesn't mean you can go out and say whatever you like, which is not true.
Well, yeah, but
because
also
you can have the position of correcting that.
Yeah, because there's this idea, because things like injunctions are equitable remedies. We've said before that the common law, the only remedy in common law is damages. All your injunctions and things, they're from equity. And there's a principle in equity that you must come to the court with the clean hands. So the idea is that unless you're squeaky clean yourself, with respect to the subject matter at hand, just because you've got a parking ticket doesn't mean you can never get an equitable remedy. But if you were to go to court and say, we want to, stop this, we need an injunction, we need to enforce this, then the defence would be, well, hang on a second, because you have spread so many falsehoods yourself, or you've put false information out there, or you've put a false impression, you are not coming with clean hands, so you don't get the injunction anyway. Somebody who had just kept stum about their marriage probably would get the injunction.
Might have an argument, yeah.
Yeah, I mean, this is the argument, because, this is all Naomi Campbell, and she was filmed coming out of a drug rehab. And the court said, well, actually, that sort of thing would normally be secret.
Yeah.
However, because she has gone out there and publicly said, I am not an addict, etc., etc. Now, in all fairness, a couple of the judges felt the other way on that and felt she should still be protected. And I tend to agree with that, because this is my, personal opinion. Being put on the spot and saying, are you a drug addict? I think sort of saying, oh, no, isn't necessarily, a bad thing to do.
It's not exactly the sort of thing one would want to answer publicly.
And also, if you're a role model, what you're supposed to say, well, actually, yeah, I am taking loads of drugs, but I've still got a very successful career. It's like, it's not necessarily, that would be a defence to say why you did it. But yeah, these little subtleties that everything turns on. And like I say, you've got all sorts of competing things here. You've got defamation, malicious falsehood, confidence, privacy, contractual obligations to silence. It all gets very, very complicated, but that's where media lawyers make their money, having these arguments. But like I said, the press are given a lot of freedom in how they monitor themselves, and with the sense of like the public interest defence, pretty much the courts will leave it up to editors to decide. They've actually said, well, the phrase they use is the courts will give a lot of deference to the editorial judgment of professionals. Now, of course, that we have citizen journalists, in England and Wales, there's no real difference between citizen journalists and just, quotes, professional journalists. In some jurisdictions there are. I mean, like in Sweden, for instance, professional journalists have protections that amateurs blogging don't. But here it's no. But in the same way that you've got the same freedoms of the press, you've got the same obligations. So if you are vlogging or just tweeting or whatever, and you're going, well, I'm a citizen journalist, think about things like, the press code of conduct, checking your sort, approaching people for comment.
And that's only right, really, is if you're going out with a camera, and your purpose is YouTube or whatever it might be, as opposed to your own personal, private family album of your day out in whatever city. It's only right that you should really check those sort of guidelines and things like that. And
and people do get caught out. And like we were saying, when certain recent stories that are quite gossip and scandal out there, if people bring claims, the average payout on something, an allegation of sort of serious criminality or misconduct, you're looking at sort of 20, 30k plus costs. And that's why people, will settle. Now, obviously, people settle defamation cases all the time. Doesn't necessarily mean, it's not about the merits always. It's quite often about the costs and just walking away from
exactly.
it.
There's a couple of things there, without speaking about any case in particular, but there's a couple of things.
I'm definitely not speaking about any cases.
There's a couple of things. First of all, we've said before that some people settle is not because they admitted it, unless obviously they expressly admit it within documents. But sometimes they settle not because they admit it, just because they want it to go away. And sometimes they settle for an amount, not because the amount reflects what happened, just because it's just an amount they agreed on. I mean, and all sorts of things happen. I've seen all sorts of, as you know, Al, I'm a mediator as well. I've been involved in lots of mediations. And I see all sorts of different values. And the interesting thing that I find from the mediation perspective, like sort of as the mediator, it's a fantastic. You've done some mediation, I think.
I've been on the receiving end of mediation. I don't mediate, but
it's fascinating. I think, and every barrister should do the training because I think it's fascinating. Because what it gives you is a fairly unique opportunity to see. I know we, as lawyers, we see each side of the argument whenever we do it, but as the mediator, you see both sides of the same argument. And it's a really unique way. It's not in a courtroom style where you hear both arguments formally. You hear what's really going on.
Oh, yeah.
And so almost immediately, as in within the first hour, as the mediator, generally, some are a bit iffy, but generally which way the flow of money is going and roughly how much from the beginning.
Yeah, because I think the thing with mediations is, because they're like on the without prejudice basis, you quite often find what is this dispute really about? It's not actually about who gets the right to go over this driveway. It's because somebody was rude to somebody's mother-in-law 3 years ago. So many times this comes out in cases where
they just want an apology. I just want them to accept that was wrong. And
that's a great thing about mediation is that you're not bound by the standard sort of it's got to be damages. It's got to be. You can settle it in any way you want. And as a mediator, your job is to sell a solution to both sides that they can live with.
And the fact that they choose the solution, because the one thing that usually comes later in the day, but it's usually when, if we're struggling to get to a resolution, it's, well, if all this fails, you're going to court, and then you'll get a decision. A judgment is a decision you get.
Yes.
A settlement is something you choose.
And a judgment can quite often be what neither of you wanted.
Yeah, exactly.
I mean, this is particularly settling. I settled a defamation case once for recovering a snooker table.
Right.
It was like somebody had a national newspaper. I won't say which one, but famous for bad spelling. In all fairness, brought this thing, pointed out and said that is clearly defamatory, it's an allegation of criminal conduct and it's just wrong. They accepted it straight away and it's like, okay, what do you want? So well, it's not just going to be your little bit in the corrections, we want some token here. But my client actually did just want it's wrong, it's wrong. And she wasn't that bothered, and it's like, well, we want some token gesture, and it's, well, tell you what, she's connected with a local Siemens mission and stuff. They need their snooker table's a bit ragged. You recover the snooker table, and we'll forget about it. And that's what they did. So you can, a court couldn't have ordered that solution.
No, exactly.
Everybody was happy about it.
Well, I had one. I can't speak to details, but there was something that was bought that was not up to scratch. They didn't accept that it was not up to scratch, but it was arguably not up to scratch. And the only way out of this scenario was to sell it. But the only way they could sell it was with the assistance of the people they bought it from, who were refusing to help. And there's no way a court was going to say, right, you help them sell it. The court's not going to do that. It's a very, very tall bar for a court to order parties to work together. I've never seen it.
Well, it swings. It's a big pendulum because of your Article 6 rights to a fair trial. There's always been this thing, and the courts whether they can certainly put pressure on you to mediate, and they can certainly encourage you to mediate, but the courts tend to like go one way or the other as to whether forcing somebody to mediate is a breach of Article 6, or whether actually forcing somebody to mediate is well within the parameters of the judge now to control access to the court. But a lack of unwillingness to mediate, it can be reflected in costs.
Yeah.
I mean, like I said, there's been appeals going either way on that, where they said, no, you can't penalise somebody just because they exercise their right to go to court, and other courts have said you can penalise people because we encourage people to settle, and if people are going to play silly and not even attempt to resolve this. I mean, the great thing about mediation and without prejudice discussions is they're without prejudice. So you can actually look all reasonable in correspondence, say, we would love to mediate, we encourage, let's have a meeting, and then sit in the meeting and go, no, we're not, just go away, we want some impossible solution. But then you can go back to court and say, well, we tried to mediate, and you always try and hint that it was the other side's fault that it collapsed. And this is why it's, drafting the open correspondence, i.e. the correspondence the judge can see without crossing into without prejudice.
Further to our open letter.
Exactly, further to our open letter, here's our real thing. Or further to our without prejudice letter, It's a shame that you wouldn't agree to our offer,
exactly.
How far you sort of cross the line there. But I mean, especially in defamation, actually, because of the hideous expense, there's been loads of schemes that people have tried to set up as alternatives to litigating. Yeah. And there are sort of various like tribunals where you pay a fixed fee and they just make a decision, and they're usually ex-media lawyers or ex-journalists or I mean, arbitration and mediation is, well, it's not just barristers and lawyers doing it, judges. It's a nice little retirement package for them. I mean, it's used a lot, alternative dispute resolution. I mean, the oil industry, they have their own special arbitration court out in the UAE that's apparently lovely, and that's all retired High Court judges just making a small fortune just to go over there and rule on things. But for instance, in defamation, we have a procedure called offer of amends, which, as the name suggests, that's just something you do very early on in the proceedings. You go, okay, hands up, either I accept it's wrong, or I don't accept it's wrong, but I want to bail out as quickly as possible. And you say, I admit everything, here's my offer of amends. And it used to be the damages were capped. It could never be higher than £10,000 if you made an offer of amends. Now, technically, they are actually open, there's no limit. But courts still reflect the fact that, look, the earlier you say, I'm sorry about this, the less it's going to cost you. So, an offer of amends. And you can make an offer of amends even before somebody issues. If somebody writes a letter before action saying, I'm going to sue you for defamation, because you have to get letters before action off very quickly because of the 1 year limitation period. If you just write back and go, okay, I'm sorry, will you accept an offer of amends? Sometimes they'll just say, you don't have to do the formal procedure. Yeah, just you correct it and apologise. That's all I'll live with. That's fine. But other times they say, no, I want the court to be involved just so I can point and say this is all went through court proceedings and it's all official and we've ticked all the boxes. But that's another way people get out of it. But fundamentally, to get back to the original point, newspapers could, if they wanted to, just make up things about you. And it could be hard if they tick all the right boxes to actually have any actionable claim. Because like Mr. X denies this strenuously. That's all they really need to do. I mean, it's not a defence to say I'm only reporting rumours, but you can say this is a story that's in the public interest. I mean, we had that with the email before the wedding, where it was probably dangerous to comment on that when it was just a rumour, but when somebody said, I am now taking action about this email, it was perfectly fine to say, oh, this is the email he's taking action about, because of course you are reporting that he's saying it's all incorrect and it's all untrue and there's more to come. And same with all the rumours. More
to say, more to report, more to talk about. And we've said before, the best way to get something attention is to get people to stop talking about it. And then
I mean, today's headlines are tomorrow's fish and chip wrappings. The best thing you can do, actually, unless it's really causing you ongoing serious harm, is just to keep your head down. And then, you know, people get bored with it. It's a news cycle.
Yeah.
I mean, it used to...
And that's the thing with the Harry Meghan stories is, on the one hand, I mean, it's hugely ironic. On the one hand, there's been a lot of report of them wanting privacy and not to be in the headlines, and yet somehow they always end up there. And so I've said in previous videos, it probably is, as you said before we started recording, probably is either the source or their friend or someone close to them or house sitting, whatever it might be. And they always seem to end up there. So it's hugely ironic that they end up back in the headlines day after day. And so I wanted to have this chat because I was coming down and to see you, and it's nice to see you and to prove that you're actually on...
still here.
You're actually in the room and still here. And talk about these things, because there's lots of these stories. And I've been sitting on them for a few days thinking, well, my Black Belt Secrets, you know, make sure you subscribe to Black Belt Secrets, by the way, if this bit's on Art of Law. But what we really think, you can feature on there as well, what you really think, and what we really think of these things. I mean, do we think there's any... Let's have this now then. Do we think there's any truth to these things? Right, let's go through them. Do we think there's any truth that they were denied passage on Air Force One?
I have no idea, because the thing is, like I said on my Night Lawyer video, one of the big problems I had when I worked for newspapers was I never actually know who anybody is or what's going on in the real world. And I do see these things pop up. I only get stuff from actually watching your channels. Quite possibly. I mean, the thing with Air Force One is, obviously it's the... Well, actually, technically speaking, Air Force One is a call sign. Any fixed-wing aircraft that the president is on is Air Force One. Any rotary wing aircraft is Marine One. So that's a little thing there.
Fascinating.
Yeah, you see a lot of people. So there are, because there are several Air Force Ones at any given time, or planes that can be. But yeah, they do transport. You know, the president goes, but the press travel on
because they've got all sorts of press and all sorts of you know, envoys and ambassadors. I
mean, there might be sort of weird, you know, because it's a bit like, you know, how you can only go in a police car if you're under arrest, you know, because they're not insured, and you know who they actually take on board. I mean, would you want to take the responsibility to travelling folks who is still technically very close in the succession to the throne? I mean, one thing I find fascinating is that Lilibet, their daughter, is constitutionally eligible to be both Queen one day, but also President of the United States. And that's an interesting thing. We've been chatting with my American constitutional lawyer friends as to whether that could be at the same time. Were they refused? Yeah, quite likely, because it's not a taxi service. And I can see the Secret Service going, we've got one high-profile person on here to keep an eye on. You know, this is beyond our remit. And you would get into, because, you know, there's all the stuff about they don't get the close protection and they don't get the armed close protection and, you know, things like that. How would you reconcile the security? I mean, if you were the Secret Service, would you want to have the responsibility for an heir to the throne? No.
Well, on the one hand, they'd have to almost choose the priority to protect, wouldn't they, if anything happened? So,
well,
I can quite believe that they were turned down. But I think they would, in my view, they would have wanted to be on there, but most likely turned down.
I suppose it all depends on how, you know, the implication is it's like, we demand to go on Air Force One. If it was just do you think there's any chance of a lift, mate? No, sorry. It could be as innocuous as that. Can you just see if they could give us a lift there? And they say no, you know, but you can blow that up into all sorts of
could be as simple as that. The divorce, what do you think? Well, talk thereof or happen?
Well, you know, relationships are always tricky. Who knows? I mean, they might be the most loving couple in the world. It's very... Having your private life, you know, what is effectively your private life, scrutinised in public, who knows what's going on? I mean, they must be under a lot of pressure. I mean, I think the court case, I mean, we saw in there, and, you know, reading the book, just from Harry's perspective, how he feels hounded by the press and the pressure and what they're doing to his wife, who presumably quite likes, because, you know, they are married. I mean, this might make them, they might be actually one of the tightest, strongest couples going, just because of all the external pressure.
Indeed,
I mean, it's always tricky, isn't it, to sort of speculate. I mean, it's very easy to say about any sort of celebrity relationship.
Is, I think it's more common than not for couples to have fights and arguments. And I think anyone that's close to them that isn't completely loyal to them, that has heard any kind of argument or whatever, or him going to a separate room for the night, they're probably going to leak it, aren't they? I mean, that's the reality.
Absolutely, yeah. And it's, you know, that's the trouble, and you know, they have staff, and okay, there'll be NDAs in place. But this is part of the problem of being a celebrity when news gets out there, is the paranoia as to where it's coming from. And that's what we saw a lot with the phone hacking, because it's like, I can no longer trust my friends and family. Yeah. Because how were they getting these stories?
Well, in that sense, you know, in that sense, I think Harry is in a really difficult position if he's got to that point that he's so paranoid that he doesn't know where this comes from, that he ends up in the High Court suing over it. My personal view is, you know, some stuff might have come out from the palace, and some stuff might have come out from some, you know, workers or journalists or whatever, you know, without their, you know, input, consent, whatever. But I don't think it's nearly as bad as he says, and that's just what I think.
No, I always think
he's a bit paranoid.
Well, with the press, because this is one thing, you know, I always notice this. If I have any personal knowledge of a story that's in the press, I always go, well, they got that wrong, they got that wrong, they got that wrong. Now, what are the odds on it? It just happens that they only get the bits wrong that I know about personally.
Exactly.
You know, I apply. So, you know, should I apply that same standard to everything else? And yes, you should exercise some critical thinking. Yeah. I'm not saying the press got their way to deliberately lie, but they're under time pressures, they don't necessarily have the expertise, they are to a certain extent reporting on gossip.
They sometimes spell legislation wrong.
They do. They say equality, they say
the Equalities Act.
Equalities Act when it's Equality Act. And Geneva Convention when it's Geneva Conventions. That's my little bugbear. Yeah. But yeah, I mean, always apply some critical thinking to any story in the press, because, you know, news is a perishable commodity. You need to get it out there quickly. Especially if it's an exclusive, because there's no copyright in news.
Again, even on YouTube, if it's, even I'm not a journalist, I'm not a news company, but even then, I do spot that when I've got something out quicker than some of the big news, because it's me and a camera, and I can just flip it on and record and get it out quicker than most of the news companies sometimes. It does really well. It gets lots of views, and I'm convinced that it's because it's news and it's out quick and it's first, and the algorithm, which has got something like 80 billion with a B data points that it analyzes what to serve you up as a video, as a viewer, it knows that it's news. It knows that it's new, and it knows that I'm one of the first to get it.
It's scary how the algorithm
works.
Really
scary, yeah.
But yeah, you're just getting things out there first. You don't have time necessarily to sort of do all the background checks and things, and again, that is a defence in sort of claims against the media, is to say, well, the courts recognise that, like I say, news is a perishable commodity, and there is time pressure.
Yeah. There we go. So there are our views. They can, to some extent, they can say anything and they can make it up, but they probably won't. They'll almost always get something wrong, I think it's fair to say. I doubt there's any story that is 100% completely accurate, almost ever.
No.
Because there's bound to be something that could be very, very slightly more accurate. But,
well, yeah, because, you know, and also, like, you know, people don't necessarily have the expertise in the relevant field. I mean, like I say, you know, my other big bugbear is legal proceedings are always, you know, I'm not saying they're deliberately misleading, but they're never quite accurate. And that's why I think, you know, with like yourself doing the demystifying and commenting, and that's what I try to do. And like Joshua Rosenberg was perhaps the last of the proper qualified, legally qualified journalists, although he's sulking now, is he? Because he's refusing to pay the £25 that the law system, the SRA insists you pay, even if you're not practicing. Just to say you are a solicitor. Because you know, Joshua's a really, I mean, he's a very well qualified person. There's an interesting thing, actually. A judge recently said that. We were talking to some law students, and he said, great if you're considering going into law. He says, but I'd like some of you to consider being court reporters, because we don't have that anymore. Yeah, and it's a massive loss to, I mean, this is why I very much shifted from not having cameras in courts to stop us all grandstanding to actually, no, I think the more transparent the system is, and the more people can see, then the better it is for the justice system. But it has to be that you can see everything without it being edited, without other people's
comments. I was going to say unedited, and just raw, absolutely.
Yeah, and you know, it's great that you can have people commenting on this, but as I always say, you know, don't just take my word for it. I'll give you my ideas and my take on it, but you know, other sources are available. Although, just to come back to a bit of legal thing, this is a problem recognising litigation, when you do a witness statement, one thing that a lot of people forget to do, but you're supposed to, is you're supposed to put all your sources of information. So you're supposed to say, this is my own personal knowledge. I know this because a friend told me.
Yeah.
I know this because I read it. I know this because I checked some old emails I had or read the company accounts. This is the whole thing in terms of weighing up evidence.
Yeah.
It's not just what people are saying, it's where is the information.
Weight, yeah.
Is it internally consistent? Is it consistent with other people's evidence? Is it consistent with documents? This is the assessment that we do in courts, but it takes like years to get something to trial. We've got a long time to read that. If you're of a newspaper, when I used to do my night lawyering, and it's like a story's come in and it's like, quick, get it typed up because it's going to press in 10 minutes.
Yeah. There's a difference then, isn't it? You haven't got months and years, you've got 10 minutes.
Nobody says stop the press anymore, you see, because there's an old phrase which was stop the press, which was, this is an interesting story, because they physically had to stop the presses.
Yeah.
And you'd get this little bit where they'd leave a bit blank in the corner of one of the pages where they could just make a little play to just stamp the the breaking story and that. Now it's all digital, we don't have that anymore.
Well, there we go. So there we go, there's our views. Thank you for watching. Make sure you like the video and subscribe, both here on Art of Law and here on Black Belt Secrets, whichever channel you happen to be watching this little bit on. And thank you for sitting with us. That's been, I don't know how long it's been now, but
it's been 42 minutes and 22 seconds, according to mine.
So thank you for joining us, and we'll do this again, and we'll see you next time.
Take care.